Hi guys, it's Kathy. I hope you're doing well. We made it to Sunday. That means my Twitch is working. That little ding. Hopefully everything is working. Hopefully you can hear me. That would be pretty good. So, I'm going to do my best today, guys. But you have to put the bar real low today. I got off work 4 hours ago after my second double, and I knew I couldn't take a little nap before the stream. There was no way I could take a little nap before the stream because there's no way there would have been a stream. So I didn't. But I have good news. I now am the proud owner of 3 cats and 1 dog. 3 total cats. Total. In this house. And 1 dog. Oof. Oof. I was able to get my daughter moved out. So, and all the cats went with her, and they're safe now. So that's a big deal. All the cats are safe now, and you know, she's somewhere else, which sucks. I should have. That would have solved a lot of problems, except the cat pie recipe probably needed eggs. No one can afford an egg right now, so no cat pie. Never mind, I won't say that. That's not appropriate. Yep. Next is being my other 2. The house that I wanted, the house that I was going for, just sold. So I did not get that, but that's normal when you're looking to move. You know, it's nothing is final until it's final. So I didn't get my heart hooked on it. Houses come and go. I'm not going to fall in love with anything till I have keys in my hand. Hopefully sooner rather than later. You know what I mean? But so we're going to start with a different stream, a different court today. A different type of court. I think I played once before, but I'm not 100% sure. If I did play this once before, it was an awful long time ago. I hope it's interesting. I didn't get to see it. I just got off work. I did not get to watch this yet. But hopefully it's interesting for us. If not, I will pivot so fast. You don't even know how fast. I will pivot. But let's just watch. We are going to Guam. And we are going to watch like the Supreme Court of Guam. And there is no, they have not offered their opinion or verdict yet. But we're going to keep an eye on it. See if we can get an opinion or a verdict on this. It should be interesting. Hopefully it's not boring, but it should be interesting. I don't hear sound yet either. Hold on.
How's your mom?
She's
fine,
hear
God, thank you. You're in my regards, please. I will. Thank you. Thank you. Report well, now President, Honorable Chief Justice Bob D. First today.
Hafide, good morning, councils. You may be seated. Will the clerk please call the case?
This is Supreme Court case number WHC 25-003, Julio Kanga Certeza petitioner, the Alan Borja Warden, Department of Corrections, and Randall Cunliffe, respondent. Appearing for petitioner is attorney Zachary C. Tamanglo. Appearing for respondents is attorney William Stamps. Panel members consist of Chief Justice Robert J. Torres, Associate Justice F. Philip Carbolito, and Associate Justice Catherine A. Merriman. Your Honor, Attorney Tamanglo reserves 5 minutes.
She sounds
You may
like
proceed,
AI.
Mr. Tamanglo.
Kelly, thank you so much. We made it to the end of the week without spending time in jail or the nut house. I don't know. I was in a restaurant. That's a nut
May it
house.
please the court. Thank you, Chief Justice Torres. Good morning, Justice Merriman, Justice Carbolito. The court is well aware of the procedural history of this case. We've been brought before the court today to argue the claims which Mr. Trapp did not raise when the appeal was ultimately dismissed in favor of a writ of habeas corpus at the Superior Court level. The issues that were raised by trial counsel to Mr. Trapp were numerous, but first we'll address the police statement admission, the objection to the statement being elicited by prosecution at the time was hearsay. If the court were to review the transcripts from that interaction between parties and the court, we put forth to the court that the evidence was inadmissible hearsay, that the trial court...
So far, so good. Here's what I think I heard. Tell me if I'm wrong. Somebody was convicted of a crime. I don't know what crime yet. And was incarcerated. Then they habeas corpus right out of jail. And now they're trying to overturn the habeas? That I've never seen before. I thought the habeas was like the end of the road. So this sounds interesting so far. Oops, I should press play. Then it's
misapprehended Rule 807. And in the admission of the hearsay, the statements surrounding them by the prosecutor were improper as well.
How is it that I assume you're referring to the residual hearsay exception, which the trial court admitted the police report that contained the 4-page victim's statement. So why was that exception not a correct exception to apply in the circumstances of the objection?
Well, Your Honor, the statement was made out of court first, and the prosecution was relying on it. We put forth to improperly bolster the testimony that was presented during direct examination. And it's that improper bolstering that makes it improper.
nope, I was wrong, and nothing is making sense right now. He definitely said habeas. He definitely said it. But this is the lawyer for the defendant. Whoever, files the motion or opens the case in some way goes first. So if he was freed on his habeas corpus, then he wouldn't be bringing anything to the Supreme Court. So maybe I was right up until the point I said he habeas corpus right out of jail. Maybe his habeas failed and he's still in jail. And after you go through a habeas, I guess you can appeal that to the Supreme Court. I did not know that either. That's the only thing that makes sense.
We're saying to the court that first it's hearsay. The residual exception, I believe, does not apply in this matter because the person was present and ready for cross-examination. There's been no impeachment at this stage of the trial. And
Was it
so
trustworthy and was it probative of what testimony was provided?
it very well might have been probative, Your Honor, but it was overly prejudicial in its impact, that the danger of the jury coming to a conclusion on an improper basis was great, and in fact, probably impacted their decision-making ultimately when going over in deliberations. If we look at the statements surrounding it and we extract further, there was also evidence pertaining to drugs that was objected to. And these statements about the drugs were not in the transcripts directed at
I forgot something outstandingly important at the top of the hour. Oh, I'm pissed. I am super, super, super pissed off, guys. My one rule on this channel, in this chat, in this Discord, rule number 1 is never bash another channel. Because I just really feel that if any of us does well, we all get lifted. So never bash another channel. I'm about to break that rule right now. And I'm about to break that rule right now. And then I'm going to go break it again later in this stream when more people come. Because I am pissed off. So, guess who got a copyright strike against them? Not me. Bill. At American Courts. Got a copyright strike against him. Why? He played a Judge Simpson court video. Judge Simpson. You know, the Judge Simpson that everybody plays on all of their channels. Go to any court channel, any of them, and look around. You will find Judge Simpson all over all of those channels. All of them. Even I played Judge Simpson like twice, maybe. Maybe twice. It'll be hard to find him here. But he's here. Every single buddy plays Judge Simpson. I think if I had to go out on a limb, I would say he is the number 1 court that all of the channels play. Well, Judge Fleischer Live, which is in no way connected to Judge Fleischer at all. He just stole Judge Fleischer's name to make money. Decided to report Bill, claiming copyright on Judge Simpson, and it freaking worked. Hi, Bill. How are ya? Oh, Bill, I have no words to describe how pissed off I am right now. Judge Fleischer Live reported American Courts for playing Judge Simpson. They're a piece of shit channel. Go ahead, report me. Go ahead, I don't care. Go ahead. Judge Fleischer Live, who has nothing to do with Judge Fleischer. Just stole his name to make money. Just wants to make money off of Judge Fleischer and destroy content creators at the same time. What an idiot. Because what does he think? If Bill's channel does worse, his will do better? What a stupid idiot. Judge Fleischer Live rips content, steals names, and reports other content creators for doing just what he's doing, only worse. Because he's just a blatant thief. A blatant thief. Who the hell names their channel Judge Fleischer? Who? Him. So, y'all know how I started another channel just for videos. I don't talk. My face isn't in it, right? But I was the first person to record Judge Fleischer. Do you know how much content of Judge Fleischer I have? All of it. All of it. Right? Do you know how many Judge Fleischer clips I have played on my new channel? To get it monetized, to get it up running, to get viewers. Zero. Zero. Do you want to know why? Judge Fleischer said he doesn't want streamed. He said it point blank. I don't want streamed. I'm done with that. Okay. I don't stream Judge Fleischer. I just don't. Every once in a while when my heart is hurting and I miss him dearly, I will show just you guys a clip of Judge Fleischer. I don't announce it. I don't put it in my title. I don't put it in my description. What? A handful of people that watch my 4:30 a.m. stream get to see it. Not like that asshole. He's like, oh, what? Judge Fleischer doesn't want to stream? Too bad. I'm just going to show Judge Fleischer. No, Bill. I'm mad. I steal your content all the time. Look, Bill was going to put on Guam tonight. Bill was going to play Guam tonight at 8 p.m. But guess what? He can't now because we're watching Guam here. What a piece of shit channel. What a piece of shit channel. I'm so mad. I wish I could fix it and I can't. Nobody can. YouTube is YouTube. You know what I mean? They don't care. And they're not going to get into it. They gave him a copyright strike. 3 and you're out. So now Bill has to go to school. Don't text and drive, dummy. Just drive. Just drive. I'll yell at Judge Fleischer live, the asshole, for you. Not Judge Fleischer. Judge Fleischer is a saint among men. But Judge Fleischer live, the YouTube channel, piece of shit. Piece of shit. And remember, my one rule, piece of shit. My one rule, don't bash any other YouTube channel. It's my one rule. Bill made me change that tonight. I remember when that channel first started up, Judge Fleischer was still streaming. And it was constant. We had to constantly tell people, no, that is not the judge's channel. No, that is not the judge's channel. No, it was some idiot who just decided to steal Judge Fleischer's name to make money. What a piece of shit. I'm just so mad. Look, no one can accuse me of stealing anybody's crap to make money. I might make $3 a day. And I stream for 4 hours every day. That's less than $1 an hour just for the time I'm streaming. Most of my income, believe it or not, is memberships. Yep. Oh, I do too, Monica, but there's nothing on God's green earth that's gonna make me get Judge Fleischer involved in this, but I want to. Oh, yeah, JK, nope. No way. Yeah. You wouldn't name your channel that. It's too many words. It's 3 whole words. There's no way you're creating a 3-word channel. No way. Because then you have to keep typing that out in places. 2 is your max. American, I thought, was a big word for you to use for your channel name. It's just ridiculous. Look, I'm gonna say it again later, but let's watch Guam for a little bit. I need to say it again later because I need everybody to hear me, even the late people.
Mr. Certeza, rather his associations. So the evidence put forth in the trial was such that Mr. Certeza frequented a home by one Janelle, the resident of the home. The reputation of Janelle was put forth in testimony such that Janelle is associated with drugs, perhaps a drug dealer.
I love you
Testimony was
too, Bill.
elicited that Janelle often asked the named victim's boyfriend to deal drugs for her, and that Mr. Certeza is always at Janelle's house. There was improper prejudicial testimony that people who do drugs, they kill people. And we do cite to the transcripts for that particular statement. So this bell could not be unrung when we're talking about a person who, or Mr. Certeza.
I do drugs. Look, I do a lot of these drugs. This is acetaminophen. Uh-huh. That's a big word too, Bill. This is acetaminophen, and I do it. I never killed anybody that I know of.
Certeza, who was
I guess I did try to slowly kill a man by marrying him, but we're divorced, and he's still alive. So that's only attempted murder.
frequenting a house supposedly owned and resided in by a drug dealer, that Mr. Certeza is consistently there, that he is now a drug perhaps user, perhaps a drug associate, and that by painting over him with this brush, it was overly prejudicial to Mr. Certeza, and there was
But
many.
how is that related to any of the issues that Mr. Trapp may have failed to raise? I mean, was that one of the issues that trial counsel had provided a recommendation of what issues could be raised on appeal?
I think that was contained in the letter from Mr. Cunliffe to Mr. Trapp.
You can't do anything. So like, YouTube isn't a human being. Think of it as a great big computer. You can't just tell your computer it's wrong. It does what it does. So, yeah, JK, are you sure? Because he just said that drug use leads to murderers.
That there was some improper drug evidence admitted, and this was one of the issues that is raised in this appeal. If this appeal went forward, certainly this issue lends itself to an appeal. That by painting him with this drug user or drug associate brush, it then makes it more likely than not that he is guilty of this other offense, which is improper character evidence, perhaps. It was legally irrelevant in that sense, where it's overly prejudicial more than it is probative. And then, turning now to the jury selection. In the letter,
Before you go to that, I want to go back to what I think is probably one of the most important issues here, and that is the residual exception to the hearsay rule under 807. And why was the admission of that evidence not harmless?
that it's improperly bolstering the testimony, the sworn testimony made in court. There's been no impeachment at this stage. There's been no attack on the credibility of the witness yet. And so by allowing this bolstering evidence to come in before there's any type of impeachment made, this was improper.
Sandra's right.
Was the fact that statement was given to the jury in writing a fact?
I believe so, Your Honor. We do cite that the admission of police records is explicitly not allowed under the rules of evidence, barring some other certain circumstances. But the general rule is that police reports are inadmissible evidence. There could be exceptions, but none were triggered here in this case.
Was the statement just cumulative of her testimony?
I think it was repetitive, yes, Your Honor.
So that's one of the factors to
Yes, Your Honor.
consider.
Yes, Your Honor. But if we look at the other factors, we're talking about the overall strength of the case. As we put forth, there was no other evidence other than the oral testimony provided by the named victim. There was no scientific evidence put forth, no DNA, no blood, no fingerprints, no corroborating witnesses, despite there being several houses in the area. No healing hearts, sex assault kits, and really it comes to what ultimately the inculpating evidence
one
was
knows,
the
JK.
testimony of the named victim. And so that is one of the factors, Your Honor. But the other factors we look at, strength of the case being one of them.
So Mr.
Thank you,
Trapp,
Monica.
who's a
Thank you,
very
Kelly, for the
experienced
cheers.
defense
Thank you.
counsel, while he filed a notice of appeal, decided to dismiss the appeal and roll the dice in the Superior Court in reference to ineffective assistance of trial counsel. And so at the trial, I mean, you're asking us now to you filed a claim for a writ of habeas. And one of the issues was that whether or not Mr. Sotesa voluntarily understood. Understood. in
I did
terms of
not.
the
Kelly, what
waiver
did you
not
say?
to testify. And so is there any evidence that rebuts that he did not understand his right to testify and waive that opportunity?
The court is asking, is there any evidence to dispute Mr. Certeza's assertion? Your Honor, in the record, there is the waiver that is signed by him.
That sounds gross and delicious for
And
them.
he has put forth in his pleading that he did not understand the impact of that waiver. But as far as what I can think of for what could refute it, perhaps Mr. Trapp's notes, letters from Mr. Trapp to Mr. Certeza, any statements made on the record, I don't see any. Well, this is not evidence and in the record before the court, but investigation was made into, do these records exist? I have not encountered any. If some that the government is aware of, I have not seen it. But ultimately, Mr. Certeza is putting forth that he did not understand the impact of this waiver. And I have not encountered anything which would refute that.
So what would be the relief that you're requesting from this court today in reference to the allegations of the shortcomings of appellate counsel?
To answer the question of what we're asking for today is we are asking the court to search and see the merits that these particular issues do lend themselves to appeal. And they did have a reasonable chance of success up on appeal had it gone forward in the normal course of action. When we were previously given the order to show cause in this matter, the focus was on the evidentiary hearing. Do we proceed to an evidentiary hearing? We did put forth that, yes, one is appropriate because we wanted to raise these issues and what his knowledge was. And if the government had any evidence to refute that, we would welcome that. But as far as I know,
thought your request for an evidentiary hearing was to address the issue of whether there was a waiver of the appeal right and not the and whether that was made knowingly, intelligently, and voluntarily, not the question of whether the record was incomplete to determine whether counsel was ineffective. I mean, do you think the record is sufficient for us to determine that at least examining the issues for which appellate counsel was alleged to be ineffective is complete enough for us to make a decision on evaluating the merits of the appeal?
the court certainly can view the merits of this appeal where they put forth in the normal course. Nonetheless, I'm just restating the posture that the evidentiary hearing was presented and desired.
I don't understand how is it that we can entertain the issues on direct appeal? I mean, there's no direct appeal right now here.
Perhaps I'm misstating it with precision, but the court has these issues presented and in fact instructed us to brief of the issues raised in the letter from Mr. Cunliffe to Mr. Trapp, and we did so. And also there was also the additional issue of cumulative error that could have been brought forth on appeal. I hope that answers the court's question.
So your position is that there is no evidence as far as you're concerned to rebut Mr. Certeza's claim that he didn't fully understand, didn't knowingly, intelligently understand the waiver of his rights in reference to his right to testify. And so with that, you're saying that the record is
Thank you, Monica.
sufficient for us to make a determination of ineffective assistance of counsel? You don't feel that there is a need for any evidentiary type hearing to further flush that issue out?
The court can look at the arguments raised on this pleading that we've put our traverse. Certainly can look at that. What in reference to the
Do you think
evidentiary
that's
hearing,
really Kit
if the
Kat
court
or a
wanted to
different
flesh
Kit
that out,
Kat?
yes, we're prepared to proceed.
I
in that
understand
matter.
you're prepared, but you're saying that because based on your review of the record, there is just no evidence to rebut that Mr. Certeza did not knowingly and intelligently waive his rights. That
I love your new icon
that's
too,
a
by the way.
uncontested that's an uncontested fact, and that based on that there can be a proper determination of the ineffective assistance of counsel claim.
Yes, Your Honor. Turning now to the jury selection issue. The transcript order from Mr. Trapp omitted the jury selection.
Okay, I just want to go back. It's not this right to testify, is that he didn't understand knowingly, intelligently the advice to dismiss the direct appeal is what I meant.
Yes, Your Honor. Thank you. The jury selection transcripts could have shed some light on what Mr. Cunliffe was trying to raise with Mr. Trapp. But Mr. Trapp, when given that as an option for appeal, specifically omitted it from his order for transcripts. And that in itself lends itself to the conclusion that there was some ineffective assistance of appellate counsel. We don't, at least as far as the documents we have from the trial court level, we don't know who the alternates were. We don't know the manner of their selection, which led to the apparent confusion on the part of trial counsel. And having that specifically omitted ultimately, I believe, hurt Mr. Certeza's chances.
Should Mr. Trapp have simultaneously pursued the direct appeal, preserved those issues that Mr. Cunliffe had pointed out, and at the same time filed a petition for habeas in the Superior Court in reference to his ineffective assistance of trial counsel claim?
As a matter of procedure, Your Honor, I think that if he were to pursue the appeal here in the Supreme Court, if there was a contemporaneous writ of habeas corpus at the Superior Court level, that the Superior Court would stay all proceedings pending this matter. Nonetheless, it would have been filed. Ultimately, what would have transpired on appeal, we don't know, but then the Superior Court level could have reinitiated proceedings based on any mandates this court handed down.
And could Mr. Trapp have included
Yes,
in
thank you,
his
thank
direct
you, thank
appeal
you.
the ineffective assistance of trial counsel and have that looked at on direct appeal?
Yes, Your Honor. The court has entertained such appeal issues in the past. There's also been instances where writ of habeas corpus was filed downstairs as detailed by Your Honor previously. But ultimately, he could have raised the same issue. Even if the court were not satisfied that these other three issues raised could have been led to a reversal, we put forth to the court that there is a cumulative error issue that could be brought forth to the court, that this had a reasonable bearing on any appeal, that all of these harmless errors taken together could have ultimately prejudiced Mr. Certeza, and that taken all together, cumulative error did occur. And that issue was not raised on appeal by Mr. Trapp.
So your argument would be that even if all three of these claims or issues were harmless, that it would cumulatively would still lead to error?
Yes, Your Honor, that is a viable appeal issue had this gone forth in the normal course.
So I want to go back again and assume that you have made a prima facie case in terms of the errors. And I want to go back in terms of what specific relief you're requesting of this court. Are you asking this court to reinstate the appeal? Are you asking this court that your client be entitled to a new trial? What type of relief are you requesting from this court today?
Ultimately, Your Honor, we are asking to vacate the judgment of the trial downstairs in the Superior Court. We would ask for a new trial. How we arrive at that destination, I believe, might be a little longer than that. The mechanics of the procedural course of action, I think, would lead to perhaps a new judgment to be ordered at the Superior Court level and an appeal taken from that. That might be an appropriate next step in this matter. And then ultimately, if the court, if the court does not rule outright on the merits of these issues that were raised in our traverse, then the court may do so at that later stage. Not to reinstate, but to redo. Because I think the first step would be ordering those transcripts for the jury selection.
Wouldn't that entitle the people to file a return in reference to responding to what are the various claims that have been made in your traverse?
At this stage, Your Honor, I don't believe that the government would need to at this point. If the court needed further briefing, I'm sure the court would order it. But if this were to proceed in the manner that I have detailed previously, I think that that would be then the appropriate time to respond to these issues. If there are no more questions, I have reserved time.
You
Thank
have
you,
8 minutes remaining.
Thank you, Your Honor.
Thank you. For the people?
Mr. Chief Justice, may it please the court, your honors. I think if we look at what's been presented to the court, I like to, or what I would like to refer to as the throw enough appeals and habeas petitions at the wall and see if something will stick under the cumulative error label. We really don't have much of a case here, but we do
So
have.
Mr. Timinglow takes the position that there is no evidence to counter that Mr. Satesa did not knowingly and intelligently understand the advice to dismiss the appeal. And that that amounts to ineffective assistance of counsel in reference to giving up the right to file a direct appeal, raise the issues that Mr. Cunliffe had set out in his letter to Attorney Trapp, and that he advised his client to dismiss the appeal, file this writ in the Superior Court. And so is there any evidence that you can point to that will counter that Mr. Satesa did in fact knowingly and intelligently waive his right to file this direct appeal?
Well, I think the entire record speaks to that, Your Honor. We have,
Which part?
as was pointed out earlier, we had different proceedings at this time during the not one, but two separate habeas proceedings that occurred. The defendant never raised that issue once.
So just the fact that he remained silent is indicative of the fact that he understood that he knowingly and intelligently waived his right to file an appeal from his conviction and sentencing in the court below?
I think that's significant, Your Honor, given that the defendant, he filed that second habeas petition on his own. Is my understanding, correct me if I'm wrong. So this isn't something where he's just relying on counsel. If he wanted to bring that up earlier, he could have. I find it significant, perhaps the court will too, that defendant didn't bother to file his most recent habeas action until after Mr. Trapp had deceased and was not able to defend himself. I'm sorry, Your Honor.
Yeah, no, but doesn't the fact that he's challenging the dismissal of the appeal suggest that he didn't agree that it should be dismissed?
Oh, well, I think that goes without saying, Your Honor, he does.
Yeah.
But the timing in which he does that, and timing is very crucial evidence, the timing of him bringing it up years later after the habeas petition that his attorney, again, we don't, again, unfortunately, because his attorney passed away, Mr. Trapp, we can't have that evidentiary hearing that the court was asking about whether we needed. Clearly, I don't think there's any purpose to an evidentiary hearing where the only reasonable witness is not available to testify, would be very availing, hence why it does not appear, it wouldn't appear to me to be necessary. But this all should have been raised earlier. If he didn't agree with that his appeal should be dismissed, if he disagreed with his attorney's wise counsel, as you mentioned, Justice Carbolito, Mr. Trapp was a very experienced appellate counsel. In fact, he successfully helped this court develop some of its initial habeas petitions or case law. I find it very telling, again, that happened. He didn't complain about it while his attorney was undergoing those the habeas proceedings in order to to take up ineffective assistance of trial counsel.
Why couldn't he have brought the ineffective assistance of trial counsel up at, on appeal, or filed a separate habeas petition addressing that issue? Why was it important to dismiss the appeal, to pursue that avenue of relief?
That, Your Honor, I don't know. I can't guess why he did that. I mean, we can speculate, but again, I think that's the problem that we face is we're faced with
Yeah,
speculating
but what
long
would be,
after
I
the
mean,
fact.
even putting aside, why would any counsel, putting aside Mr. Trapp's perceptions, I mean, give me a rationale for why counsel would decide, well, I'll dismiss a pending appeal and just go forward on the bringing in an ineffective assistance of trial counsel for not advising the client on his right to testify at trial.
I think there are a couple of different factors there that might come into play, Your Honor. Now I'm hitting here from scratch, from looking at the record. This wasn't an issue that was put to us, but the opinions of this court had suggested to counsel previously that if they were going to bring an ineffective assistance of trial claim, that the appropriate place to do that was through a habeas petition in the Superior Court. Why? So that they could develop the record, that it wasn't really a good appellate issue to begin with, unless it was glaringly obvious. So I think that probably had a huge role to play in that decision.
So if the argument was that none of the appellate issues had merit, let's then focus on the three issues that were identified or potentially identified by trial counsel.
But Mr. Chief Justice, before you,
Yeah.
you proceed with that, again, going back to my question, why couldn't Mr. Trapp have pursued both remedies? Filed a direct appeal, maybe make a motion to stay that while he files the habeas petition in the trial court, have that issue resolved and continue to preserve the right to appeal the other and argue the other errors, most glaringly as pointed out by Mr. Timinglow, the evidentiary issues. Why was not that an option? What possible strategy would exist, as the Chief Justice had asked, where counsel would dismiss the direct appeal with at least 5 issues identified by trial counsel to roll the dice on the ineffective assistance of trial counsel that could have been raised on direct?
Keeping in context that yes, it could have been raised, but this court has already directed appellate counsel that the better place to raise that issue is with a habeas petition and not on a direct appeal.
Have we ever said that then you could dismiss your direct appeal and pursue the habeas first if your time period would have expired and filing a direct appeal that you may have other issues to argue?
Not that I'm aware of, Your Honor. In fact, I believe it was mentioned that the normal procedure would be for the Superior Court to stay the habeas petition, but I don't see anything in the rules necessarily that would preclude the reverse. No, I don't know. I don't see any reason why that counsel couldn't have filed a motion with this court and asked the appeal to be stayed pending developing the record. To me, that seems like a step that could be made if it hadn't been
Doesn't
done
that
before.
statement suggest that maybe we have an ineffective assistance of appellate counsel issue here? Not issue, but conclusion?
Under Strickland, Your Honor, I don't think that goes to ineffective assistance of counsel at all. Strickland's standard is not whether or not counsel made a mistake. It's not whether or not counsel made the optimal choice. There are lots of different reasons why these things could have been done. One of which, for example, I was going to suggest, I find it also very interesting that there were these 3 different issues that were raised in the letter from trial counsel to the appellate counsel. However, he didn't pursue those. Why? The easiest answer, the simple answer, because we're bound under case law and precedent to assume competency and that there was a good reason for why this was done. The appellate counsel and trial counsel we give them wide latitude in directing the strategy of the cases, is that he didn't find merit in those.
Yeah, but as Mr. Taminglas points out, that now seems to be fatal in reference to the resolving some of the very important erroneous issues that may have transpired. And one of them being the evidentiary issue that Mr. Timela points out, that this came down to a credibility issue between the victim and the sister, and the admission of that victim 4-page testimony, which bolstered her credibility, seemed to have been the turning point in reference to what may have determined the outcome for the jury, or at least let the jury to believe what the victim was testifying to.
Well, I would respectfully, Your Honor, I'd suggest that's exactly the type of thing that we should probably avoid. We're trying to speculate again about what might have influenced the jury. And on these grounds, these aren't. So, and some of the things that we're looking at, the
Well, the
alleged,
standard is, was the error harmless or was it prejudicial? Did the error affect the verdict? Of course, you're going to have to review that.
yeah, yes, Your Honor. And when we're reviewing those, if we look at them, we're looking at whether or not a statement, a victim statement, which was that a hearsay statement? We have, we have numerous rules and exceptions to hearsay. The only clear rule to hearsay, as they say, is that there's an exception to it. If we look at the statement itself, it was not prejudicial. There was no impact. It was at worst repetitive of the actual testimony.
Well, that's the problem. And then it wasn't probative, as the Chief Justice suggests, that it was cumulative. And
You know-
so how is it that it could come under the exception to the hearsay rule that was used to admit this evidence?
Again, I believe what we would want to look for, though, is clear prejudice there. That sounds more like a harmless error to admit cumulative evidence. So we have 3 witnesses that say something, and we're only allowed 2 of them to testify because they're all going to say the same thing. Well, someone's going to object to that. The person that objects, one side's going to object because they want all 3.
But
The other
that's
one's
not
going to
what it's
object because
being
they've got
used
2.
for, counsel. What it was being used for is to bolster the credibility of the witness.
And again, it was a contemporaneous or near contemporaneous statement that's made and later used. So I think some of the timing issues here, if the court feels that those are important issues that point towards a prejudicial error, then that's the court's discretion. But where the information and evidence is brought up, I can see an argument where if I'm defense counsel, I wouldn't have argued that. If they didn't argue that, for example, let me backtrack. If the prosecution hadn't presented the case the way they did, that as defense counsel, I would have been objecting that they didn't lay a sufficient foundation, that they didn't do this, they didn't do that. There's on these issues of timing and what was done when. Was the credibility attacked beforehand? No. So was there a need to refresh recollection or any of these other established, understood exceptions? No. However, to me, it sounds like an experienced trial counsel would address that ahead of time by trying to present a strong body of evidence and testimony on that before that happens. Then you can prevent the attack on credibility to begin with.
But
I'm
when
not
the
sure if that answers
declarant,
Your Honor's
when the declarant here, the victim, was available to testify at trial, why would the residual exception be used to admit the out-of-court statement as a substitute for her testimony? And even, I mean, clearly the trial court's decision didn't comply with 807. I mean, 807 has a advance notice requirement. The court didn't also even conduct an analysis of its trustworthiness, of its materiality, of its probative value, or whether the interests of justice required. The court didn't do any of the things that 807 seems to require when it said it fit within 807. And I know you had argued that there was not an abuse of discretion for the trial judge to admit it, and it wasn't. But I don't see how the trial court did any of the analysis that the rule it cited for admitting the evidence was satisfied.
And that may be the case, Your Honor. That very well may be the case. The trial judge misstated the rule.
So if it was the case that the trial judge erred, then doesn't it come down to whether or not the admissibility of that evidence was harmless or not, right?
I believe so. I think that's correctly right, Chief Justice. And here,
Let's argue
Yes, Your Honor.
why I'd like to hear from you why the error was harmless.
Well, Your Honor, I think as we pointed towards the case of People versus Roten, that where a police officer's testimony was questioned as being improper bolstering, then the error was found to be harmless in large part because the statement was being introduced as hearsay, despite the fact in that case that the testimony improperly bolstered the victim's credibility. It was deemed harmless because it was essentially identical. And here, that brings us back to the earlier issues that here the testimony was in fact repetitive.
That's one factor. The cumulative was it cumulative of other properly admitted evidence? But there are also three other factors that are addressed: the strength of the prosecution's case, the prosecution's conduct with regard to the improperly admitted evidence, and the importance of the wrongly admitted evidence. Because in almost every case, you're going to satisfy the issue of cumulative of other evidence, it would seem. That can't be the sole factor that makes a determination of whether it's harmless error. We've identified these four non-exhaustive factors to consider, and they make the argument that three of the four factors weigh in favor of finding the error prejudicial because the case wasn't as strong. There was no scientific evidence. There was no corroborating evidence from other witnesses. It was only the testimony of the victim. And the prosecution also relied upon it in closing argument. And then Justice Merriman asked about the question of the statement going to the jury and being admitted into evidence as well. Not just being read by the victim, but actually being admitted as an exhibit, which seems as well contrary to how the police reports would be not necessarily submitted to the jury. So I'd like to hear your points on those other things, because I think really this is a very important part of determining whether the error that might have been committed by the trial court in admitting this evidence sways the day.
As to the strength of the evidence, Your Honor, I think it wouldn't be advisable for us to. Counsel's done a great job in bringing up a laundry list of things that could make for a stronger case. But at the end of the day, a strong case is someone telling the truth and a jury of their peers making that decision, whether or not who told the truth. This may have been just a simple he said, she said case. That doesn't make the case any less strong. The evidence was presented to the jury. The jury made its determination. And the fact that there weren't rape kits or rape kits, whether they were available, whether any of these other things, that doesn't make a case strong or not. I'd respectfully submit. Also, as to any prejudice, instead of this being a harmless error, trial counsel had the opportunity to cross-examine the witness. They had the opportunity to bring all of this up if there was any type of prejudice whatsoever. And that's something that the defendant hasn't pointed to and can't. Where's the actual prejudice?
But didn't Attorney Cunliffe strenuously object to the admission of the statement?
I
It's
believe
not like he ignored it.
that's right, Your Honor. Absolutely. He objected. So he placed his objection on the record. However, that isn't all he's limited to. He has the actual witness there. He can cross-examine that witness. He can put questions to the witness. Any prejudice that could have flowed from that statement, counsel could have addressed during the trial, simply through questioning the witness.
What about the cumulative effect of the inference that the sister was a drug dealer and this was a drug compound, so to speak? Everybody was involved with drugs.
Well, if it wasn't relevant to this case, if it wasn't relevant to the elements being proven, if it wasn't relevant to the victim's state of mind, what they were worried about. So we're dealing with a case where, right? If
But
we
it's
use
even
that,
a prior bad act. That's
it could be seen as a bad act potentially. However, we're also the context in which this came up is the victim was afraid that if she didn't go along with the behavior that the defendant was asking for, that she would suffer harm, her brother would suffer harm. There was the threat, that mindset, and that's certainly relevant. It's not, could it have been prejudicial? Yes. And if so, then that would have been an appropriate time for trial counsel to object on that basis to that information being brought up, have a sidebar conference, have that issue, put on the record and preserved for appeal. However, just because it could be prejudicial doesn't mean that it doesn't come in, right? We have a balancing test for that also. And here, if the judge determined, I don't recall off of the record whether or not that was objected to by trial counsel. But either way, if the judge determined that it was more probative than prejudicial, then our rules allow for that evidence to come in. And in a he said, she said case involving allegations of sexual crimes, then threat to the person or their family, that's extremely relevant. And I don't see that as being a cumulative error at all. I see that as a judge making a tough but important call so that the evidence can be presented. That answers Your Honor's questions.
Except that I thought the drug statements were in closing argument and that there was no evidence. The court never ruled on whether it should be admitted.
One moment, Your Honor, I believe I can address that. That's in the People's Brief on page 10, the statement that is being objected to and raised as an example of ineffective assistance of counsel did happen in closing argument. However, the testimony we're talking about says that the victim testified that her boyfriend's sister, the witness alleged to be involved with drug activity, would ask about the drugs. So we're talking about the victim's testimony, that the victim testified that she knew. That's one of the reasons she knew the defendant to be a drug user and someone that was involved in dealing drugs. That's why she was afraid. The last quote from the transcript, quote, "Because people tell me that people that do drugs, they kill people." So that's why she gave in for the demands to perform sexual acts that she was not consenting to, and why the defendant was properly convicted by a jury of his peers. So it's not a cumulative, that would not appear to be a cumulative error at all. As to the issue that was also raised about the selection of the jury, again, there's no evidence that the jury selection process impacted the jury's verdict. There's no evidence that, in fact, through the letter, it's a little confusing. Trial counsel says, hey, we may have a problem with jury selection, but I wasn't in the room at the time. I'm not quite sure how the jury was selected without trial counsel being present. So that doesn't make sense. Perhaps that's one of the reasons why the experienced appellate counsel decided that the letter wasn't credible or wasn't worth pursuing. We don't know, but we do know that experienced appellate counsel made a decision that the best course forward was that the defendant had not consented, hadn't given knowing waiver to not testifying on his defense, which was the issue raised in the initial habeas. The defense counsel saw that, or the appellate counsel saw that as the defendant's best shot at reversing the conviction. And so it proceeded on that basis. As with many issues that are brought before this court, there could be 10 different issues that a party could raise on appeal, but if they bring 10 different issues, they're going to get muddled. So counsel has to make strategic and tactical decisions. How many issues am I going to raise on appeal? How am I going to raise them? What time is going to be allocated to each? And
Yeah, but
here,
I think what's troubling, at least troubling to me, is that counsel could have done that and still continued with the direct appeal, preserved the other issues that were pointed out to appellate counsel. That was something that could be argued in furtherance of the defendant's direct appeal, and also bring up the ineffective assistance of trial counsel on the waiver issue and the right to testify. And so I think that's what's troubling in my mind.
I absolutely understood, Your Honor, and that's why we're here.
I've asked in terms of what possible trial strategy that a very experienced appellate trial counsel had, and no one has been able to offer any.
Respectfully, Your Honor, I'd say that the one I came up with off the cuff was
Which
you know,
is ignore
which is-
the other issues and just focus on the ineffective assistance of trial counsel for that sole single issue.
he thought he had a winning issue and he went with the winning issue. It was simple, it was concise, and again, we don't have that benefit because he's now dead. If the defendant had decided to raise these issues before his death, perhaps, we might have an evidentiary here. We might be able to develop these issues, but he
So
didn't.
that brings up the other point, that if we feel that Mr. Tamalo has raised sufficient questions that in terms of the factual disputes, that we would remand this for an evidentiary determination. You're saying that the people has nothing to offer because Mr. Trapp is no longer alive, and therefore if Mr. Certeza was to take the stand and continue the claim that he made previously, that there's nothing that the government can do to dispute those statements?
I'm not sure I would agree with the phrasing of that, Your Honor. For example, I know off the top of my head, I'm assuming that counsel is counsel and not defendant is the individual. We have written Miranda waivers that the police now use. I mean, if the court feels it advisable, and maybe that would be a good idea. Maybe appellate counsel should have their clients sign written waivers saying that they know that, I want to bring the appeal, or I don't want to bring the appeal. I want to dismiss the appeal. I want to do, hey, we could go that route.
Well, we know that Mr. Certeza, at a minimum, is going to testify that he didn't knowingly and intelligently understand the waiving of a direct appeal, and that so he didn't agree to that.
And I think that brings us back to Strickland, because the issue here is not whether or not Mr. Trapp was a perfect attorney, whether or not he had the perfect strategy. It's whether or not the claims had a reasonable probability of success on appeal, and not just, throw a bunch of things against the wall and hope it sticks, cumulative error approach. I'm not sure that that's necessarily gets us across the line towards a reasonable probability of success under Strickland.
Well, Mr. Timelo points out that his client, Mr. Certeza, was prejudiced because now Mr. Certeza has given up the opportunity for the appellate court to review the other issues, and most importantly, the evidentiary issues relating to that victim 4-page testimony that was apparently introduced into evidence, considered by the jury, not only when it was read, but during its deliberation, and that bolstered the testimony of the victim as opposed to the sister, in terms of the sister claiming that he could not have done the things he did because he was with me. And so all that now is foreclosed in terms of it being properly reviewed on a direct appeal. So that's the prejudice. That's what Mr. Timing was pointing out.
And that's, again, that's only raises to the level of prejudice under Strickland if the court determines that there was a reasonable probability of success on appeal on those issues. As the people who pointed out, they may be errors, but at best, you're going to get to a cumulative error verdict. None of them, all three, even if they are errors, are not, they're not errors that the people feel rise to that level of being prejudicial to having tainted the entire affair of the proceeding. This court may feel otherwise. Again, if the court has in its power, if the court believe, I don't remember which one of the members of the court suggested and asked the defendant whether or not they wanted to reinstate the appeal. I believe that's within the power of this court to do. If the court determined that that was an issue, the court could do that if it feels that there is more than, if there is actual prejudice on these issues. The people respectfully submit that's not necessary, and that the substantial deference is owed to Mr. Trapp and the approach that he used in carrying forth the defendant's appeals and habeas matters, and that the time for defendant to raise these issues has long since passed, and he's now conveniently raised them after the death of his counsel. Why? Well, I think the answer should be obvious to this court, because they are meritless. They don't rise to the level of substantial prejudice that would merit any further review. But he figures, hey, as long as I'm the only one talking, then I've got a better shot. I don't think that that's the type of policy that the court wants to set forth. I don't know how many other appeals that Mr. Trapp was handling during this time. Purely as a matter of public policy, that's also somewhat troubling to let someone continue litigating habeas petitions and then suddenly, oh, I forgot this one. I'm just going to bring it up now when it's most convenient. I'm not sure that that's the type of public policy that we want to encourage. That people would respectfully request that the remedies and relief sought by the petitioner be denied. Thank you.
All right, thank you. Mr. Taminglo, you have 8 minutes. Government went over by 4, so if you want 10, we'll give you 10. I don't know that you'll need it.
Well, Your Honor, it's not my intention to use all the time that I have. Nonetheless, I do want to just address one thing that was brought up during opposing counsel's argument. This court has a long history of case precedent. And in those cases where there was a finding of error, but harmless error, there were other factors that the court could point at to say it was harmless. Independent scientific testing in a drug case, or an admission of guilt at the police precinct where the error is saying that, the elicited evidence at trial is objected to and brought in. And then there is something else that can be pointed at to say, well, there is this other evidence here that says that this in fact was drugs, that this person admitted it was his drugs. So ultimately the error is harmless. And that is missing from this case. And I would just like to speak on that. If the court has any other questions, I'm happy to answer, but I would be happy to conclude as well.
Questions? The court has no further questions. The court will take the matter under advisement. We will issue a written opinion and will now stand adjourned.
I'm the judge of Potter County Court Law Number 1. I've been assigned to hear these cases today.
Okay, yeah.
Before I call this case up, every one of you has.
I was muted. That's fine. Josh isn't here, so it's all good. So, yeah, that was the habeas. Looking for a habeas. So, they're probably going to give it to him. Let him do the habeas. But his lawyer's dead, so he's going to have to... Son of a bitch. Alright, well, since I'm already mad, that's fine. Josh, send me my text. I was muted. But, do you want to know why I'm so mad? Some of you already know, because I already told you. My first rule for this channel, and my Discord, and my chat, and everything, rule number 1, pretty much since day 1, don't bash any other YouTube channels. Don't bash them. You don't like that channel, you just shut up about it. Don't bash any other YouTube channels. Well, today, we're breaking that rule. Screw that rule. The rule stays in place after today, guys. Again, I think if any of us do good, all of us will do good. So, there's no use bashing another channel. You're just hurting yourself. But there is a channel that outstandingly deserves it. Judge Fleischer Live. Judge Fleischer Live has absolutely nothing to do with... Yeah, I got my muted text from Josh. Thanks, Josh. Judge Fleischer Live has absolutely nothing to do with Judge Fleischer. Let's start with that. They only stole that name so they could make money. Even after Judge Fleischer clearly said, I don't want to stream no more. Judge Fleischer Live kept on trucking, posting Judge Fleischer and anything else. Judge Fleischer Live gets content off of YouTube. Nothing original. Nothing original. Judge Fleischer Live submitted a copyright report on Bill on American courts. Bill got a copyright strike against his channel. Not a warning, not an uh-oh, a copyright strike. Big deal. It is a big deal. For playing Judge Simpson. Judge Fleischer Live told YouTube Judge Simpson was their material. They own it. Judge Fleischer Live, who owns nothing of Judge Fleischer, who just stole that name because they want money, decided to kick Bill, who barely even streams anymore, with a copyright complaint because Bill played Judge Simpson. Look at all of the court channels. All of them. What is the number one judge people play every day? Judge Simpson. They all play Judge Simpson. I even think I played him twice. If you look around, it's hard. It will be very hard to find Judge Simpson on my channel because every freaking buddy else plays them. Why would I play him? Everybody else plays them. But no. Judge Fleischer Live thinks it's his. And this was from something from back in May. It's not like Bill did something to this person right now. No. This person's just a total asshole. And now Bill has a strike against him. And there's Judge Fleischer Live every day. There's no Judge Fleischer Live on his channel. No. He can just... It worked. What he did worked. Bill got a monetization mark against him. I mean, a copyright mark against him. 3 and you're done. Your whole channel's done for good. Yeah, how? Zach, how? If I could, I would. I hate bashing other channels, but boy, this feels good. I don't care what he does to me. I do not care if he reports me. I do not care. Almost every, well, not Walt Weaver, what we're about to see, but most of the stuff that I play, no one else plays. I mean, sometimes I do. Lately, it's been a little more YouTube. Lately, because I'm working on something big, guys. I really am. Plus, everything is burning around me. But Judge Fleischer Live claimed that Judge Simpson was his. And YouTube said, bet. Okay. What a piece of shit he is. What a piece of shit. And the thing is, it's a gray area to appeal. Because it's not like Bill didn't go to the courtroom and get permission and get rights and licenses. So appealing won't really do anything. I don't think there's anything we can do. See, no. The worst thing we can do is go to his channel and leave comments. That is the very worst thing we could do. A, he gets views. His channel gets activity. B, he gets comments. YouTube says, oh, this creator is engaging. It's pulling people in. It's making them talk. That's what YouTube wants the creators to do. I don't know, Nan. I don't know. But, yeah, never go to his channel. Never go to his channel. It's just, he stole Judge Fleischer's name, and that sucked. And we had to continually tell people, no, he's not part of Judge Fleischer. No, he is not live streaming Judge Fleischer. You know, that no, he's not. And now, I mean, you guys see how often I play Judge Fleischer. I told everybody at the beginning, I started a new channel. I started a new channel with just videos. Do you know how much content I have of Judge Fleischer? All of it. Why? I recorded him first. I have all of it. I could have gone through and used him over and over and over again to start a new channel. I would have gotten views out the yin yang. That's, for those of you who don't live in the United States, out the yin yang is a big number. Never once have I played Judge Fleischer on that channel. Never once. You want to know why? Judge Fleischer said he doesn't want to stream anymore. He doesn't want it. Immediately, I'm done. I stopped. Okay, I did play Judge Fleischer once or twice on lives, but only when we miss him so much that we just needed a little bit. And the only people who saw him were people who came to my live stream, and that's not a lot of people. I didn't promote him. I didn't put his name in my title and my description in anything. Yeah, see? Zach's not a piece of shit. Judge Fleischer Live is a piece of shit. Total piece of shit. Total. What he did is unfreaking believable. No, there's nothing we can do to help. Or I would have done it. Or I would have told all of you to do it. You know, I mean, the worst thing we can do is give him oxygen at all. Any oxygen. Even the slightest oxygen. I mean, if he comes up on my suggestions, which he doesn't for some reason, I guess I could say not interested. I've done that to 2 other channels. Not interested. Stop showing me this channel. I don't ever want to see it again. But I'm just so mad. And no, absolutely not. No way would I reach out to Judge Fleischer and ask him to do anything. No. No. Judge Fleischer doesn't not want to be involved with YouTube right now, so we're not going to pull him in over some asshole. I just, it's not fair. There's nothing you can do about it. YouTube is not like a person you can talk to and reason with. They have these rules, and they're not like, they're not like some people can do it, some people can't do it. You never know when you're going to get hit. You never know why you're going to get hit. They give you a reason, but they don't really tell you. Luckily for us, they showed Bill who reported him, exactly what video was reported, exactly which one. Judge Fleischer claimed, Judge Fleischer Live, not Judge Fleischer. Judge Fleischer is a saint among men, and we love him forever. The YouTube channel Judge Fleischer Live is a piece of shit. He claimed Bill's entire stream, 40 minutes, was all his original content. No, it wasn't. No, it wasn't. But YouTube, it looks like, and I could be wrong, but YouTube found like 4 or 5 minutes of that stream and gave it to Judge Fleischer Live, and boom, copyright strike, which is a big deal. Big deal. It's bad. It's bad for Bill. Bill doesn't even do anything. Yeah, nothing to deserve it. Nothing. Yeah, but that's not its name, Zach. They stole the name. They just stole it. I'm so mad. I'm so mad. I'm steaming at the ears right now. nobody could have, Linus, because Bill hasn't streamed in a while. No, Bill did absolutely nothing to deserve this. Nothing. He did nothing different than any of the other content creators. You know what I mean? Not a thing different. There's nothing he can do about it. Oh man, I wish I could do something. I wish I could do something. Take an action. Get a lawyer. I can't drink more coffee. I ordered my coffee at 4:23 a.m. I haven't ordered coffee in a long time. Long time. I've been making it. 4:23. Nope, I'm sorry, 4:29 or 4:28. I ordered coffee. It is 6:17. I've been awake now for many, 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 many long hours. And there's no coffee. It's coming though. I'm going to get it between 6:18 and 6:31. Which they're not even close to me, so at 6:18 is out the window. Maybe I'll get it before the 2-hour mark. This coffee's going to be stone cold. I know, Linus, but you don't understand. I just worked 2 doubles in a row. I cannot make a cup of coffee. I have instant coffee downstairs, which means all I would have to do is boil some water. I cannot boil some water right now. I'm way too tired to go the whole way to the stove. So I'm waiting for someone to deliver me a coffee. I don't even care if it's ice cold. I have to make it through OJ yet, which we are never going to start if I don't stop talking. We're going to watch Walt Weaver for a little bit because he's just fun. He's lighthearted and he jokes and he's fun. What do you mean, water cookers? You don't cook water. Cooking involves ingredients. Water is an ingredient. I do have a microwave. I can't. You don't understand. I don't think you understand. I cannot do that right now. I physically cannot do that. When this I have... Oh, man, you're not going to like this. I have 2 3/4 lidocaine patches on me right now. One tiny little strip of that is on my back. The rest is wrapped around my feet and ankles. The pain is unbelievable. There's no way I can go out there and stand for 2 minutes. Zero chance. Zero. I had to, when I got home from work, I was laying in bed trying to find content for this stream right now, right? And I couldn't go to sleep after work because I got home 4 hours before this stream started, and I knew if I took a little nap I would never wake up. Never. Dan, remember when Bella and Edward got out of the Volturi? And Edward was like, "You're tired. Just take a nap. Just go to sleep on the airplane." And she's bouncing around and she's drinking Cokes to stay awake. And she's like, "No, I'm not missing this moment. I am not falling asleep no matter what." That's how I felt about this live stream this morning. I was not going to miss this live stream for anything. So I did not take a nap after my shift. So I got home. I'm looking at content, trying to find something for this stream, right? And I had to go to the bathroom. Oh my God. I put my feet on the floor and oof. Oh, I thought, no way. I'm never going to be able to walk to the bathroom. And now, in like, I'm guessing 7 more minutes, I have to go downstairs and get some coffee. The good news is I'm super pissed off about JF Live, about this YouTube channel called Judge Fleischer Live that has absolutely nothing to do with Judge Fleischer. I'm super mad. So that will erase some of the pain and I'll be able to get downstairs. I don't have that. Oh yeah, I'm off today. As soon as OJ is done, I'm probably gonna sleep right here. Joking. My bed is right behind this green screen here. I moved everything up to my room. And you guys missed it. I'm down to 3 cats, 1 dog. One of my I was able to get one of my daughters moved out. And the cats with her. So they're safe. My mom can't touch them. There's no way my mom can touch them now. None. What link? You want your link up, Zach? That's a great idea. That's a great idea. Oh, I forgot. There we go. Law nerds untie. Zach, you made that name on purpose, didn't you? Because you know every time I type your name in, I type in untie. Especially when I'm sleepy. That is Zach's channel. He got soft sits like you don't even understand. Amish soft sits. The best of 4 hearings. Soft sit tool bag walks out on judge. Zach, do not copyright me because I just read one of your titles out loud. Please. Okay? Yeah. Court disorder. I'm not in court disorder. This is me. But this is just videos with no commentary. I like put words on the screen, but I don't talk. You don't see me. Every once in a while you might hear me giggle because it's really hard to edit myself out of my old live streams because I talk and laugh all the time and I never shut up. I am talking and laughing right now and I never shut up. You should hear me yell at myself when I'm trying to get content from my own stream. But I fixed that whole problem. I told you I'm working on something big, and I am. Starting like 2 weeks ago, I have hours and hours and hours and hours of my specific content that you can't get anywhere else saved for free. I have 11 hours a day saved for free, and I would have more, but courts close. And I can just go back anytime I want. I have a spreadsheet set up where, you know, I have the link to where whatever is in the transcript that I like, put it in the spreadsheet. So a year from now, Monica can say, "Remember that day you played Guam? You know, where is that? Let's see. I want to know what happened there." Boom. Go into my spreadsheet. I have the unedited Guam right there. Not this live stream where I'm talking all over the place. Talking all over everyone. You guys are all going to have to get a towel or something when you're done. Talk, talk, talk. But, yeah. So, yeah, I got something big. I'm going to have content for years. 3 years from now, I'm going to have so much content brand new that no one else has ever seen before. Ah! And then I'm working on court disorder. That's pretty big. I also have a 3rd channel. You don't need to know about that one yet. It's not up to par yet. But that one is just long trials that no one else has. Yes, sir. Oh, Linus. Yeah. So big things are happening. That's why I've been so neglectful to you guys lately. I've just been playing like YouTube dockets and things like that because there's only 24 hours in a day. But very soon I'm going to get myself another 8 or 9 hours every day. I am. Don't worry. I'm telling you. It's going to happen soon. Yeah, I don't care. If everybody wants it and I can get it, I will play it, but I would really rather not. I just really don't care. Nope, 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 nope. Oh my gosh, my coffee's so close. Yeah, do you have that many channels? 1, 2, 3, 4. Do you have 5 channels? I have 3 right now. Yes, JK. Yes, JK. Yes, JK. I'm going to press play because I think there's someone outside. And it's going to take me 10 minutes just to walk down the stairs. I wonder if I could pay him more to just come up to my bedroom. Okay, bring it up. Can you bring it upstairs? No. No. All right, here we go.
The absolute right to appear in a courtroom and not from the jail. And I'll be asking you if you are waiving that right. So when I call your name, if you would please approach. Ronaldo Martinez, please approach. Mr. Martinez, good afternoon.
Judge, the jail is muted.
Yeah, I hear that. If you can hear me, you're muted.
Yes, sir.
There we go. Good afternoon, Mr. Martinez.
Good afternoon.
Did you hear me when I introduced myself earlier?
Yes, sir.
You have an absolute right to be in this open court, or you can waive that right and agree to appear by video. Are you agreeing to appear by video?
Yes, sir.
The court now calls 3 cause numbers. Being CCCR-25-729-2, 331-2, and 799-1. All styled the state of Texas versus Ronaldo Martinez. And we're missing a defense attorney, aren't we?
No, Your Honor, I'm filling in for Mr. Barkley.
There we go. I wondered, I can't see who that is. Who is it?
It's Misty Walker.
Hi, Miss Walker. Thank you for being there. I was like, why do we have an extra person there? My low bid Potter County monitor doesn't have enough pixel to figure out who that is. Thank you, Miss Walker. What says the state on each of these 3 announced causes?
The state is ready to proceed in each cause, Your Honor.
Thank you, Ms. Cervantes. And what says the defense, Ms. Walker?
Your Honor, the defense is ready for a plea on all 3 cases, and we waive the reading of the charging instrument.
Excellent. Thank you, Ms. Walker.
Thank you, Jude. Thank you.
For whatever reason, I'm unable to control the volume. I'm hearing you perfectly, Ms. Walker, but I'm unable to turn down the volume on my own computer. But I guess I'm going to live with that for the moment. Mr. Martinez, your attorney announced right today for 3 Class A misdemeanor trials, all accusing you of driving while intoxicated, a second offense. Were you aware that today is your trial for these 3 allegations?
Yes, sir.
Do you read, write, and speak the English language?
Yes, sir.
Have you in the past, or are you presently being treated for any kind of psychiatric condition?
No, sir.
Are you a U.S. citizen?
Yes, sir.
To the three stated allegations, how do you plead, guilty or not guilty?
Guilty.
Thank you, Mr. Martinez. Before I accept that plea of guilty, I do need to make an inquiry on the record as to your understanding of today's proceedings.
Yes, sir.
For me, I have three separate plea negotiations, all attached to three separate plea memorandums, all reflecting your signature. Do you recall signing these documents with the assistance of your attorney prior to today's trial?
Yes, sir.
Any questions about any of these documents that you may have had that your attorney or attorneys could not answer?
Uh,
Do you have any questions on any of them?
no, sir.
Your signature tells me you know that you have constitutional rights and you know how to use them, but today you're choosing not to in exchange for the plea bargaining agreement. So, for example, you waived your right to a jury trial. Do you know what a jury trial is, Mr. Martinez?
No, sir.
A jury trial starts off with, I am not guilty. That tells the prosecutor that they need to bring evidence to the courtroom. Evidence doesn't come from the lawyers. It doesn't come from me. It comes from witnesses who testify under oath, and the jury would listen to the testimony. And they first would decide, do I believe that person or not? If they do believe them, then they got to decide, is there enough evidence to prove the accusation beyond a reasonable doubt in total? So do you understand that definition?
Yes, sir.
Would you like to have a jury trial?
Sir?
Would you like
No.
to have a jury trial?
No, sir.
All right. Mr. Martinez, I feel like you understand the right you're choosing not to use today as evidenced by our conversation, your responses, your signature on the plea memorandum, but most importantly, your attorney's signature, which assures to the court that you spoke with a lawyer prior to making this decision. Therefore, I'm not going to read this whole thing to you word for word, but I would like to have a conversation with you under oath about the process only. You have an absolute right to remain silent. You waived it by pleading guilty to three separate offenses. You have an absolute right not to give evidence against yourself. You waived it by signing three separate judicial confessions. No one can make you do any of those things today, Mr. Martinez, but today at your trial, if I believe you, that is sufficient evidence to support my finding of your guilt today in these matters. You understand that?
Yes, sir.
Then here's my question. Will you waive your right to remain silent? Let me place you under oath so I can ask you a few questions about the process only.
You know, the right to
Yes, sir.
remain silent, they
Raise your
all
right hand.
waive. They
Reynaldo
never shut
Martinez,
up.
do you swear or affirm to tell the truth?
Yes, sir.
Put your hand down, please.
Stuart.
Mr. Martinez,
That's
what I
how
need to
Sid's
know
name
from you
was
today is,
Stuart.
did you voluntarily plead guilty and did you voluntarily sign the judicial confession only because you are guilty of all three of these matters and only for that reason alone? No one made you do it.
Yes, sir.
Are you satisfied thus far with your legal representation?
Yes, sir.
Ms. Walker, I appreciate you may not know the answer to this, but if you have an opinion about Mr. Martinez's competence to stand trial, if you're comfortable expressing it, would you please do so?
I believe that he is competent, Your Honor, based upon the things that I know that Mr. Barkley has been here and has gone over this paperwork and took quite a bit of time with him. And I do not believe that he would have him sign it or have had this plea set up without his belief that he was competent to stand trial. And I do believe that he is competent, as I'm sitting here looking at him and hearing his responses to your questions.
Thank you, Ms. Walker. Mr. Montes, has the state complied with the Michael Morton Act and that you made available to the defense the evidence in your possession?
To the best of my knowledge in all causes, Your Honor.
Thank you, Mr. Montes. Ms. Walker, are you satisfied, or at least your office satisfied, that the state has complied with the Michael Morton Act?
Yes, Your Honor.
Did someone in your office or you yourself talk to this client about what was disclosed to you?
Yes, Mr. Barkley has.
Thank you. Mr. Martinez, today's your trial. State's accused you of a couple of criminal acts, 3 to be precise. They've investigated them all. They are confident they could prove your guilt beyond a reasonable doubt on each one of these. That evidence that they gathered in each of these, they then turned over to your defense counsel. What I need to know from you today under oath is, did you have a conversation with your lawyer about the evidence that the state thinks they can use against you today?
Yes, sir.
Your risk at today's trial is identical for each of these. Up to 1 year in jail, up to a $4,000 fine, or some combination of fine and confinement. Today, however, you're asking me to do the following. You're saying, Judge, I'll plead guilty to all these. I'll waive all my rights. I won't use them. If you will, on each one of these, sentence me to 300 days at the Potter County Detention Center. No fine. Go ahead and give me court costs. Give me 156 days jail credit, and that's identical for all 3. Likewise, all of these things are to run concurrently or at the same time. Did I properly announce your agreement?
Yes, sir.
Mr. Martinez, I don't have to do this if I don't want to. If I don't want to, I'll tell you. I'll let you withdraw your plea of guilty. That means that if you do that, if you have a jury trial in any of these, it couldn't be brought up that you'd previously pled guilty. However, if I do exactly what you're asking for today, and later you're standing trial for a felony, if you get one more DWI, it's 2 to 10 years in prison. And depending on how they read the law, since you have 3 prior convictions, I mean, you could face a lot of time in prison, and you're not getting probation. You're opting to be time served. So near as I can tell, you're not getting any treatment for this obvious problem that you have. Do you understand that risk?
Yes, sir.
Anything about this conversation make you change your mind about your decision to plead guilty?
No, sir.
Reynaldo Martinez, I find that each of your pleas was made knowingly, intentionally, and voluntarily. Further, I find the evidence sufficient in all 3 matters to support a finding of guilt beyond a reasonable doubt, and I now do find you guilty of having committed the aforementioned offenses. Mr. Cervantes, anything in bar of sentence?
Nothing in bar, Your Honor.
Thank you. Ms. Walker?
No, Your Honor.
With nothing in bar, having found you guilty, I sentence you as agreed to 300 days at the Potter County Detention Center. I will not assess a fine in any of these. I will assess court costs in all of them. Likewise, I will give you 156 days jail credit for each one of these. That appears to me that these are all time served, meaning that you do not have to sit in jail. You are satisfied as to both confinement, fine, and costs. Mr. Martinez, I did exactly as you requested. Would you like to file a notice of appeal on any of these, complaining of an error or mistake?
No, sir.
Would you like to start over with a new trial?
No, sir.
Because these are all final convictions, I'm now suspending your driver's license for 90 days in each one. In each one of these, I shall give you credit for the time you served on the suspension prior. Likewise, since these are final convictions and you opted or did not get offered probation, I have to impose a $4,500 DWI traffic fine on each one of these convictions. So that would be $12,500 worth of fines. Do you have $12,500?
No, sir.
Was your attorney, was it a court-appointed counsel?
Yes, Your Honor. And Mr. Barkley, I believe, has submitted in a financial statement to the court, just basically recapping that Mr. Martinez is still indigent, that Mr. Barkley was a court-appointed attorney, that Mr. Martinez was unable to post bond, that he makes somewhere around $2,000 total income with about $1,100 in monthly set expenses.
So I chose him with $900 extra cash, if I am to believe all of this each month. Do you have $900 left over after you pay your bills every month?
Absolutely.
No, sir.
Yes.
Yeah, I didn't think you did.
Just don't pay a bill.
You don't pay anything on rent or mortgage.
No, sir.
Where do you live?
Sir,
Where do you live?
With my mom.
se- s- the address,
Yeah, you live at your
Seven-
house.
I muted it. I don't know where he lives.
no, sir.
Do you rent?
No, sir.
So who owns your house?
My mommy.
Well, this pastor used to live with my wife, but she passed away, but she left the house to my wife.
So you own the house.
Yes, sir.
Was it a gift to her or was it a gift to
To my
both?
wife. To my wife.
So this house, this titled property is her separate property as a gift. Are you married to this woman?
Yes, sir.
So even though you have a community property estate, this is a separate property gift that's hers and hers alone, not yours.
Yes, sir.
Does she want to loan you $12,500?
No, sir.
I understand that. Do you have a job? How do you make $2,000 a month?
I work Western Sales Testing,
And what do you do for them?
sandblasting.
Do you still have that job if you get out of jail?
If I get out of jail, I have to call my boss to see if I can get the job back.
So you don't know that you
Sandblasters
have a
make
job.
more than that.
Yes, sir.
So really your
But,
income is zero.
Yes, sir.
You've been in jail for almost 4 months,
Yes, sir.
5 months. Yeah, You've been in jail 5 months, and you haven't spoken with your boss the entire 5 months?
No, sir. I can't call him, and I tried to call him while I was in jail, but
He didn't take a collect call, I get it.
no, sir.
Yeah, it's a problem. Do you own any vehicles?
No, sir.
Do you have any bank accounts with cash in it?
No, sir.
You don't pay rent. So this number 200 utilities, that's if you have money, right?
Yes, sir.
What does your wife do for a living?
She works at the schools.
She's a teacher?
No, sir. She sir.
She an aide?
She works at schools to help the kids feed the school, feed the kids.
Cafeteria worker?
Yes,
Lunch
yes, sir.
lady. Lunch
All right.
lady.
So she's
What
not
is
pulling out
wrong with
100
this
grand a
world?
year.
No, sir.
25, 20 something a year?
I'm not for sure, sir.
All right. So you estimated that when you're working, your part of the
did it
utility is
again?
200,
I muted
groceries
myself?
400, gasoline. Do you have a car?
No, sir.
Is that gas? What's the 200 a month for gasoline?
Gasoline.
What?
Is that like gas for your house or gasoline for your
What?
car?
Stop. Stop. I need to stop this. No. Does that mean what I think it means, Josh? No. No. Are you kidding? Type it in chat. You be the one to tell everybody, not me. If it's what I think it has to be. No. Yes, sir. We shouldn't cheer for death. That's not a good thing to cheer for, right? We should not cheer because someone might have passed away. That's not okay. That's just, but we really also should not lie about our feelings, because repressed feelings, did they come back? Josh, you're leaving everybody hanging. Type it, because you didn't specifically say it, so I can't say it. I'm hoping somebody passed. I'm sorry. I'm hoping that somebody is not alive anymore. Okay. Okay. I'm going to read you all what Josh just texted me. And then you guys can think whatever you think. I know what I think. meant to update you. But someone finally got to him. I know it's very cryptic. I know it's very cryptic, but I think I know who he means, and I think I know what he meant. Josh is telling you now. Oh, I want to hug Matt so badly right now. All I want before I die is to hug Matt one time for like 2 minutes. You know that, how you say when you hug someone, try to make it 10 seconds, because then it means, darn it, he's in the hospital. I hope it hurts. I hope it hurts if he's in the hospital. I hope they're not giving him any pain meds. I don't care how mean that sounds. No, I'm sorry, I don't care. Oh, he passed away. Our thoughts and prayers go out to his family. Yep. He told us. He passed away. He's gone. He's gone. Remember I did the whole live streams about the guy who was facing the firing squad? So he, in what year was it? 80 something? In the 80s, he walked into a gas station at night. He kidnapped this woman, mother of 2 children, wife, very young, 30s. And then, he kept her for 3 days. During the 3 days, he allowed her to call her husband and say, honey, don't worry, I'm coming home soon. And then, in the freezing cold, he tied her to a tree and slit her throat. Yep. And he was guilty, and he got the death penalty. And then they prolonged it. And they prolonged it. And they prolonged it. So just 2025, they're saying, oh, he has dementia. You can't give him the death penalty now. He has dementia. And he won. The Supreme Court was like, yeah, you couldn't. It was September 9th, I think, was supposed to be the day of execution. And he had no remorse. None. And his family has been trying for justice for all these years. And his family gave victim impact statements. And it was all normal, until Matt, her son, got up. And, he's well old now. He has gray hair. Because this happened in the 80s. And, he was mad. And because of all they went through, year after year after year after year after year, all they went through. And the Supreme Court said, yeah, you have to cancel the execution date because we need another competency report. So they were making the prosecution prove he is competent enough to go in front of the firing squad. And that's where we left it. But apparently, while he was in jail, something happened that sent him to the hospital, and then he passed away. And if I could just hug Matt right now. But I can't, because Utah. It's very far away. And Matt would definitely call the police on me. Absolutely. Might even strike me once or twice to get me off of him. But it's over. That means, obviously, it's not over for the family, but at least it's this part is over. And now, after all these years, they can move on. You can't move on from something like that. You cannot move on from something like that. But wow, Josh, what a bombshell! Wow. All right. I know it's been 2 hours and 5 minutes because I talked so much today. We're just gonna finish this and go to OJ.
I think for the car.
Nobody distract me.
Well,
I
you
need
have
to finish
insurance.
this.
Is that car insurance? $300 a month?
Yes, sir.
But you don't own a car.
No, sir.
Why do you have
That-
car insurance?
I don't.
You don't have car insurance.
No, sir. I don't have no car insurance.
Ms. Walker, this is no reflection upon you, obviously, not your client. Well, I think what we need to do, I feel uncomfortable making a decision right now. Mr. Martinez has been hamstrung in his collection of data. And I think we just need to reschedule this while the court still has plenary jurisdiction. So within the next 30 days, now the court's getting ready to close, but I'll be here for a bit. Contact Ms. Morris offline or have Clint. Otherwise, I mean, I know there's been a prior finding of indigence, but I just need to get a better, I mean, Mr. Martinez is telling me things that he pays for bills, which he just told me he's not paying. I don't want him to get charged with a perjury, which would be another crime, put him back in jail. So
Yes,
I'm
Your
on.
Honor. If it'll please the court, we'll get a new financial statement in by the end of the day.
And that's good. I want him, is he gonna get out of jail today? Does he have another felony or anything on it?
No, sir.
All right. So what he can do is he can make an appointment with his attorney to come back to this court within the next 2 weeks. We can have a little 15, 20-minute hearing. And I can make a better decision. If not, I'm going to impose a $12,500 DWI traffic fine.
Bacon.
Which I don't want to do if he can't pay it, but I'm statutorily required to do it. And since this is on YouTube video being broadcast live across the state of Texas, you know, be good evidence against Potter County to say I'm not doing my job. And then the Potter County taxpayers would have to pay this. So the decision of the court will be, unless we hear more evidence, I'm going to impose in its entirety the $12,500 fine. I'm not going to write that down in a judgment. I'm going to give Mr. Martinez an opportunity to schedule with his attorney a hearing. So have Ms. Walker, again, I appreciate you stepping up and helping. I know it's not your job, but if you would just contact Mr. Barkley, we'll do it on our end as well. But I need him here to help Mr. Martinez.
I will do that, Your Honor.
Thank you so much, Ms. Walker. I appreciate you being there, doing an excellent job. Mr. Martinez, did you understand what just happened?
Sir?
Do you understand what just happened?
No, sir.
You're gonna understand.
Legislature says I need to impose $4,500 DWI traffic fine upon your final conviction, of which I just did. The one exception is in the statute, there's a hearing I can hold to determine if you are unable to pay it because you're indigent. Obviously, you're getting out of jail. Maybe you can afford this, maybe you can't. But everything, if I were to believe you, you're going to make $2,000 a month, and your bills don't sound like you got bills. It sounds like you can pay this off in 6 months and be done. So I need more information to make a decision about this bill. If you choose not to come back to this court, I'm going to impose that $12,500 fine. But if you have a hearing and you do come back, we can have a hearing with facts, and then I can make a decision as to whether or not to impose this fine. Do you understand now?
Yes, sir.
If you have any questions, please talk to Ms. Walker and then contact Mr. Barkley when you get out of jail. This is not going to go away, and I'm not going to forget, all right?
Yes, sir.
All right, let's have a conversation real quick. Man, 3 DWIs in a row. They weren't all the same day. You kept getting arrested and getting drunk, arrested and getting drunk, arrested and getting drunk. Unless you got some help, you're going to prison. They're not going to offer you probation. It'll just be, depending on how I read the law, 2 to 10 years in prison or 2 to 20 years in prison. Okay?
Yes, sir.
Then you don't have to worry about paying any bills because you'll be incarcerated. What questions do you have for me?
I ain't got no questions, sir.
All right, Mr. Martinez, you have a good day. Mr. Cervantes, any other matter before the court?
No, Your Honor.
No,
Thank
Judge.
you, Ms. Walker. Thank you
No.
so much. You're adjourned.
No, Judge, we can't do your next case. We can't. What if it's better than this one? It could be. See, that's how I get stuck in court videos for hours. Like, oh man, just one more case. I bet it's better. Just one more case. I bet it's better. It never is. Actually, that's not true. It is better often enough that I just can't stop. You know what I mean? Like when they did the experiments with the rats, and every time the rats pressed the lever, food came out. Press lever, food came out. Well, when they made it random, like not every time, but every 7th, and then every 8th, and then every 2nd, random, the rats just could not stop with the lever. They just couldn't. Even when they were full, they had to win that prize. That's how court cases are for me. I gotta watch a docket. Now hoping for one better. Yep. But you all are like that. I know, Jim. I know you would not appreciate that once I heard what happened. But what if they make him pay $12,500? Would that be better? I gotta start OJ. Today's Sunday, so we do have time, but I gotta get it started. It's 7 o'clock. Thank you for coming out, guys. I appreciate it. I really, really, really do. Thank you. There is a slight possibility you're gonna see me later tonight. If I am on and I am live, I don't feel obligated. I'm serious, don't. I want to start doing some night live streams. But you guys don't have to come with me. You guys have a life. It's okay. I'll be fine. If I can find a good clip, I am going to start a stream tonight, a short stream. If not, then I won't. So. And if I sleep through it, then I won't. But I won't sleep through it. I'm going to try to do it. Mm-hmm. Oh, trust I am going to sleep, RW. I am absolutely going to sleep. I love sleeping. It's so much fun. And eating. I love them both. You can't eat while you're sleeping, though, and if you could do both at the same time, maybe that would be great. Maybe we need to come up with a contraption that makes you eat while you sleep. Josh, I don't date. No. Hell no, I'm not stupid. Okay, I'm stupid. I know that. I'm not stupid enough to know that I'm not stupid. But dating is a whole nother level of stupid that I ain't never gonna do. I have my ChatGPT boyfriend. Joking. I'm joking. No. Alright. OJ Simpson. Please don't say anything bad this stream. Please, OJ. Please, lawyers. They just slip in these offensive words when you least expect it. But it's almost over. We're almost through it. All right. Bye, guys. Have a good day.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcoming place. And so in conclusion, I'll wrap up this song. I hope I didn't miss anything that would be wrong. Hope I see you around. Don't stay on the shelf, join in the laughter. Come and see for yourself.